It's Josh Boorman from Boorman Lawyers. I'm just outside Parramatta local court today. I've appeared on a middle range drink driving offence. Now, today I'm going to go through the facts of the matter and explain to you how it all came about. The bit of preparation in what we advised our client to do, what he actually went and did, and the surprising outcome that our client actually got for this particular outcome today. So as mentioned, it was a middle range drink driving offence. It was a 0.140 blood alcohol reading, and our client was involved in a single vehicle accident. Basically, the facts of the matter were that the incident actually occurred around 1:20 a.m. in late May 2025. Our client had been going through quite an emotional period of time. He was going through a marriage breakdown from his wife of the last 5 years, and he uncharacteristically went to the Westmead Tavern and drank alone. He had his first drink around 11 p.m, his last drink around 1 a.m. In that 2-hour period, he says he consumed 4 double shot Jim Beam bourbon and cokes. So double shots obviously increased the alcohol content and quickly rose his blood alcohol reading. He said his transport options were limited, which they probably were, but I mean he is the one that put himself in that situation where he decided to drive to the pub, have some drinks, and it was quite late at night. So he did make that poor decision to drive home. He didn't make it far, only about 800 metres down the road. He momentarily got distracted. He veered off the side of the road and ended up crashing into a traffic light. Completely totaled his car and knocked over the traffic light. So much to his credit, however, which is quite unusual in these circumstances, is our client actually got out and on his own volition, he was the one that called emergency services. So they arrived a short time later, and he admitted to drinking, admitted to being the driver of the vehicle. He cooperated with police. He was suffering some whiplash and bruising and a sore ankle. He was transferred to Westmead Hospital, where he was given some minor treatment, but blood sample was taken, and it eventually came back in June with a 0.140 blood alcohol content reading. So he was charged at the time. His license was suspended from June when the charge was laid, and we appear before the court today at Parramatta local court, where a plea of guilty was entered. Now, to make matters a little bit tricky and worse for him, his traffic record was not great. Between 2005 through to 2010, he had a low-range drink drive, a disqualified drive, a drug drive, and was declared a habitual traffic offender. He had to spend 5 years off the road due to that declaration. And however, since 2010, the last 15 years, he's only got a handful of more minor traffic infringements. So over time, over the last 15 years, certainly his traffic record has improved, and this has probably coincided with him settling down, maturing, getting married, starting his own business in the air-conditioned trade. In saying that, maturing maybe on the road, but not quite in relation to his criminal history. It was only 6 years ago he had some pretty serious drug dealing offences on his record. He didn't get any jail time, but he was not today subject to any bonds, parole or corrections orders, so nothing could be called up in that regard. And to be honest, in relation to drink driving offences, more of a focus is put on the person's traffic record. So as I presented to the court, in his earlier days it was a pretty average record, but over the last 15 years it has certainly improved out of sight. This was obviously a backward step for him, going through a trying period with the marriage breakdown. He went and did the traffic offenders program. He got some good references, a good letter of apology, and we presented the court well today in the strongest possible way. to be honest, today's outcome was a very positive one for our client. He was given a $750 fine. He was given the minimum disqualification of 3 months. That was backdated, so he's got about a month left to serve. He will have to do the mandatory alcohol interlock program for 12 months. And that was it. There was no other community corrections orders, community service orders, and certainly it wasn't raised up to a level of crossing a Section 5 jail threshold where a suspended sentence or intensive corrections order could have been issued. I mean, the matter was aggravated. It was a high reading in the mid-range. It was quite a serious accident, and even though it's quite dated, he does have quite a poor traffic record in the early days, but a very good, sensible outcome today. Our client's very happy. He has a clear path moving forward, and fingers crossed that we don't see him back before the criminal justice system again. Thanks for tuning in here out at Parramatta Local Court.
I want to thank you for tuning into Boorman Lawyers today. You can catch us at any of the usual social media platforms. Please subscribe to our YouTube channel. And if you've got any questions or queries, please don't hesitate to contact us on 1300 941 900. Hey guys, thanks for tuning into this video today. I really hope it was informative and helpful for you. There's another couple of videos below that you might want to check out that may be very useful for the process that you might be going through at the moment. Please feel free to like, follow, share, and subscribe to our YouTube channel because we've always got fresh new content coming through all the time.